Yes, the affidavit has been filed, no? New affidavit.
My lord.
It has been demolished.
My lord.
Yes.
My lord.
Then
Just one prayer, your lordship. Kindly have a glance on the upon the relief prayed in my writ application, your lordship.
okay. Yes.
We have challenged the notification, the acquisition proceeding, and all, my lord. And my writ was not properly adjudicated on the sole ground that they have taken the undertaking that I will be demolishing the said structure. And the question is,
That is precisely, it is precisely, Mr. Madhav Raj,
my lord,
precisely for the reason that acquisition of your land was taken for straightening the road.
my lord,
You were aggrieved for the reason that you perhaps were of the impression that but for the structure erected by the local MLA in the name of his father,
my lord,
perhaps there would have been no need for the acquisition of your land
my lord,
for proper alignment.
my lord,
This has been found to be incorrect,
my lord,
as the overbridge has been constructed, the alignment is straight, which has consumed the land which has been acquired and which belongs to you,
my lord,
and the structure also has been demolished.
my lord.
So therefore your apprehension is absolutely without any basis.
My lord, the question is when they demolish the structure, after
right.
acquiring my land,
So
or
therefore,
before acquiring my land.
so therefore if
So
the
there may be the chance, my lord,
None.
there
We
was
are not-
there
we
may
are
be
not-
no requirement of acquisition, my lord.
All that
if
you-
they had
all-
demolished the
all-
structure
No.
before acquisition, my lord.
reason is that even if it is found that without consuming your land,
Yeah.
only by the demolition of the structure the alignment would have been good, then also you don't have a right, because now the alignment is straight.
My lord.
It is not swerving in any direction,
My lord,
and therefore it is to be presumed, and it would be a legal presumption
my lord,
that your land was required.
my lord.
I don't think you need to agitate it any further.
My lord, then may I have liberty to file another writ application on the same cause of action, my lord.
What?
So we have filed the acquisition proceeding, my lord. They have
That
not
you have
treated.
done.
They have treated my land
Have
to
you,
the agricultural
did you
land.
file the writ petition after seeking approval of the bench? No.
No, ma'am.
So you have the option, you can file any petition anytime, but it would be subject to the adjudication by the courts. Don't take any liberty from us. We are not entertaining this appeal for the simple reason.
So, my lord, another time they will be telling that this application had already been challenged and is barred by the judicata principle.
No, no, no. We'll not in so many words, but we will make it very clear that it is for this reason that we are not entertaining the appeal.
My lord,
All right.
my lord.
Now we will be careful in couching our order so that it doesn't stop you from approaching the court any other time.
Obliged.
Mr. Dwivedi, when is the last affidavit that you have filed?
My lord.
The affidavit dated 27/6. All right. आपने एफिडेविट में एक लाइन लिखने के बजाय आपने हर कोर्ट का ऑर्डर को कोट कर दिया है. वी डोंट नो व्हाट इज द नेसेसिटी. क्या लिखा है पैराग्राफ 15 that stated that at the time of कहाँ लिखा है आपने कि डिमोलिश कर दिया स्ट्रक्चर?
Paragraph means 15, 14 and 15. 14.
कहाँ लिखा कि डिमोलिश कर दिया
Paragraph
स्ट्रक्चर?
number 14 it may.
हाँ?
Paragraph number
That
14.
respondent humbly submitted and stated that in the process
They have taken the benefit of the learned single judge order, my lord, that there was no time frame that by what time you have to demolish the order.
लिखे.
paragraph 14, my lord.
All right. The appellants had approached this court challenging the decision of the government to acquire their plots, their land under plot numbers 345, 355, 330 and 349, which was located by the side of the road for the purposes of construction of the overbridge by the Bihar State Road Development Corporation. First off, the reason for the appellants objecting to such acquisition was that only in order to save a tower which was erected by local MLA in the memory of his father, a need was felt by the corporation to acquire further land so as to have the alignment of the overbridge straight. Had that structure not been there, or the authorities would have taken a decision to demolish such a structure, there would have been no necessity of acquisition of land belonging to the appellants. The learned single judge, after having heard the counsel for the parties and taking into account the assertion of the respondent that the tower so erected at the place of the overbridge would be demolished, rejected the contention of the appellants on the ground that alignment of a bridge is important, as it would be a public utility and only the pedestrians and travelers would have a straight road to follow. Before us, the land counsel for the appellant has submitted. The land counsel for the appellant had initially submitted that the respondents have not carried out the promise which they had made before the learned single judge, and the tower still stands where it originally stood, giving rise to thereby giving prop to the supposition of the appellants that the acquisition of their land was motivated and only for the purpose of saving that structure. The last of the affidavits filed by the respondents indicate that the tower in question has already been demolished and that the alignment of the overbridge is absolutely straight. With this affidavit of the respondent, it becomes rather obvious that the land belonging to the appellant was consumed, and since the alignment is straight and there is no complaint in that regard, it can safely be presumed that the land of the appellants was needed for a proper construction of the overbridge. The land counsel for the appellant submits. Land counsel for the appellant, however, submits that the structure / tower has been demolished much later, and therefore such a presumption cannot be made that but for the use of the land belonging to the appellant, no straight alignment could have been made in the overbridge. The aforesaid issue is a separate grievance altogether, which cannot form the subject matter of this appeal. There is nothing in the order of the land single judge which warrants any interference. The appeal therefore is dismissed.